healing grow.
All right, we are going on the record in the matter of the state of Michigan versus Kevin Smith, 231353. And appearance, counsel?
Good morning again, Your Honor. Edward Taylor, P57166, appearing on behalf of Mr. Smith.
All right, thank you. And Mr. Shadra, you can just rejoin breakout room 1. I'm going to put Mr. Schlaff in there with you as well. And Mr. Smith, your name for the record, please. Okay, Mr. Smith, your name please for the record.
Excuse me, I can't hear you.
Your name for the record, please.
Kevin Francis Smith.
All right, and so, Mr. Taylor, today's the date for the review for Mr. Smith regarding competency. He was referred for competency and criminal responsibility, and we have not yet received a report. Have you?
I have not, Your Honor.
Okay. And Mr. Smith, have you been interviewed by anybody regarding any evaluation?
By who? I can't hear you.
Have you been interviewed by anybody regarding a psychological evaluation?
The what?
Of a psychological evaluation?
Your Honor, I can't hear you very well. You're breaking up.
Okay. Have you been interviewed by anybody, sir, at any point since your last court date?
Have I been interviewed by like who? Who you mean?
Anybody?
There was a girl here a while back asking questions about a week or so, about a week or so ago.
Okay, was that in person or was it,
Well, it was in person, but the guards were moving around, shuffling around, making noises, nothing formal at all.
okay. So counsel, I was just trying to ascertain if that was in fact, the Center for Forensic Psychiatry or not.
Your Honor.
Yes.
What happened in my life? There's a lot of issues I'd like to talk to somebody about, but not the local coffee shop owner. There's some issues I'd like to speak about, but not in a room with other talking and not with people that don't want to hear the truth. It seems like every time I want to tell the truth, people don't want to listen.
Yes, sir.
Okay.
Yeah.
Your Honor, I have.
Go
Go ahead, Your Honor. I apologize.
No, that's okay. What's that, sir?
Okay, yeah. This one is, this young man I have here, this name is
What was that? What was that, sir?
Okay. All right.
Smith, what was that you wanted me to know?
Oh, that's fine.
Your Honor, there's some new designs of products that I have
Okay.
that I'd like to claim as my own.
Okay, well, don't share those with anybody right now. And your attorney can speak with you regarding that, okay?
Okay, I never hired an attorney, by the way.
I understand that, but this court was not allowing you to waive your right to an attorney and represent yourself because the court had some concerns regarding your ability to do that. So the court appointed an attorney to represent you.
What is he representing? What is he representing for me? Is there a name for that?
I have Mr. Chesley Fuller here.
He's your defense attorney, sir. Mr. Taylor, have you had a chance to speak to Mr. Smith or no?
I have, Your Honor, but not today.
Your Honor, the one thing that I'm a little curious about is how I worked my whole life in construction and did everything I had to do in life, even going to church. How could I have nothing in life right now? Why would I have nothing in life? If I grew up around a good home and everything, did that ever strike odd to you?
Well, it could be, I don't know. So Mr. Taylor, I'm gonna put you in a quick breakout room with Mr. Smith so that you can maybe, explain the proceedings as to what's going on right now.
Yes, I understand. I'm not trying to fight anybody, but there's a lot of issues I need to discuss. It's not a quick yes or no. It's very detailed in my life itself and what has happened. Years ago, I spoke to David Palmer of the Department of Justice, and I had an issue back then. And I'm sure it's the same issue, but it just can't go on going. And I was worried about my girlfriend being raped, and I heard some real bad things about some politicians and their sons thinking they could get away with anything and hire attorneys. But it's a very serious issue right now. I've been to the border already trying to get into Canada, and they denied me the privilege, as you guys would call it, to get in. But I'm very concerned about certain things. And that's why I'm being firm about my situation now. I'd rather sit in here for a while than to ignore the chore at hand.
No, I understand. I'm gonna put you in a breakout room with your attorney so you can address your concerns, okay?
Yes, of course. And it was, most of it has to do with a girl that I was communicating with. And I just wanted to make sure she was okay. I am not anything bad in life. I stand for good, by the way.
Okay.
I grew up around the
understand.
American flag that sits right behind you. We put
Okay,
$5.58 into that flag back years ago, and that's what I stand for,
Okay.
not the jail cell.
I understand. Okay, just one moment. We're gonna go with your attorney. Okay, and then we are recalling the matter of the state of Michigan versus Kevin Smith, 231353. And Mr. Taylor, if you can please unmute and place your appearance back on the record.
Good morning again, Your Honor. Edward Taylor, P57166, appearing on behalf of Mr. Smith.
All right, thank you. And Mr. Smith, if you can please hit unmute and your name again, please. All right, Mr. Smith, your name for the record again, please.
Kevin Francis Smith.
Okay, so Mr. Taylor, you did have an opportunity to speak to Mr. Smith, correct, in a breakout room?
I have, Your Honor, and I would like to see that report before we go forward, Your Honor. I really
I'm
think.
sorry, you'd like to what?
I would like to see a report before we go forward. I still haven't got.
Medication stuff was really bad for me. It ruined my teeth.
Hold on, Mr. Smith. Mr. Smith, I need you to wait, please. I can't have two people speaking at the same time.
I apologize, Your Honor.
Mr. Taylor, you're asking for this matter to be adjourned for another review?
Yes, Your Honor, because I think we need to look at that report before I feel comfortable going forward.
All right, and the court will agree with that. The court will adjourn this to November 9th at 9:45 a.m.
I got it. Thank you, Your Honor. Have a good day.
That'll work for me.
Okay, thank you. Have a good day. We're going on the record in the matter of the state of Michigan versus Osro Graham, 231989. Mr. Graham, can you please unmute and turn on your camera? All right, and counsel your appearance, please.
Yes, good morning, Your Honor. I'm Gilbert Lloyd here on behalf of Osro Graham, P36827.
Thank you. And sir, your name, please.
Oswald Brown.
Okay, and so why is it that you are not here in person?
Because I woke up dizzy yesterday. I was feeling sick, and today I was really dizzy. So I'm sorry.
Well, sir, okay, so you're dizzy. I'm not sure why you couldn't get a ride into court.
Well, I had a chance to speak with the client. He indicated he wasn't feeling well today. That compounded by the fact that he lives quite a distance and has no, he can't drive legally, of course. I haven't had a chance to review the case with him. I've had a chance to review it with the prosecutor. Of course, indulgence, if you permit me to appear today, I assume probably resolve this matter today. The alternative, we would have to adjourn next Thursday.
Okay.
The court's preference.
So here's the predicament the court's in then. So because, Mr. Graham is ordered to be in person, and he apparently called this morning and just wanted you to represent him without being present. And then, when he was told to hang up, or when he was told that, then he had to appear in person, then he just hung up and called back, spoke to another clerk, and then claimed he was sick. So I don't necessarily believe that Mr. Graham is sick. I believe, well, yes, he may live a little bit of a distance, he was still, please don't interrupt. He was still here in court, or at least in, the city of Wyandotte on September 6th, which is when this offense occurred. And so, Mr. Graham, did you make any attempts to secure any sort of ride here today?
Yes, ma'am. That day, that was my first time ever coming to you guys' city. I've never been there, super far from where I stay. And I have no one in my life who will bring me out that way. But
Sir, you
I
were
wish-
here that day. You made it all the way out here that day.
because I drove
So-
illegally.
Okay, well, there has to be somebody in your life, or you can utilize rideshare services, or you can utilize, the bus. You can utilize their modes of transportation, sir. But you don't just get to appear by Zoom because it's inconvenient for you to make your way down here.
Yes, I understand, ma'am.
There's one reason why you're not wanting to be in person, because there's warrants for your arrest.
No, I will appear to you if you feel as if someone's going to pick me up on a warrant, but they're not going to come pick me up because I have traffic warrants. No one's going to come get me from Wyandotte for a traffic warrant. I'm already aware. I just got out of jail yesterday, Shelby Township.
What were you in jail for in Shelby Township?
Driving while suspended.
And what was the date of that offense?
Yesterday, September 10th, 11th,
Oh,
October 7th.
so while you have this matter pending, it's alleged you're still driving because that's what you were just arrested on, correct?
Yes, I have a dog that just got a C-section, and I had to take it to the vet, which was right down the street from me. And they impounded my car, and they took my dog to the animal shelter, and I bonded out yesterday.
Didn't you tell either myself or my staff or your attorney that you were dizzy yesterday and you were sick?
I said I woke up today dizzy, man. I never said yesterday.
No, you said yesterday, and then you woke up even more dizzy today. That's what you said.
Yesterday I started feeling sick. Today I woke up dizzy.
Okay. And so you were sick, you were starting to feel sick, but yet you still were with your daughter who just had a C-section.
Oh,
That was-
I had to take my dog to the vet to get a remove her stitches. She still has stitches in her stomach because they took the dog to the
You
animal
took,
shelter.
wait, I'm sorry. Did you say you had to take your daughter?
Dog.
Oh, dog. Okay, I was very confused because I thought I heard you say vet. And, I was really confused why you were taking your daughter to the vet.
That
After
should be on
C-section.
record that they took my dog to the animal shelter and locked me up and took the car, impounded the car. And I have to show up to court within 2 days. It's Shelby Township.
Okay. Well, sir, we are not continuing this matter on Zoom. You are ordered to be in person. The court's not giving you permission to appear by Zoom. You need to make your way down here legally and handle this matter. And so we're going to adjourn this matter October 19th at 10 a.m. You're here next week, right, counsel?
Thank you.
Okay. Lisa, one last person to speak to next week in detail, or too much depth anyway. All right, we'll see you back next week, sir, 10 a.m.
Okay.
in person.
Okay.
All right, we are on the record in the matter of the state of Michigan versus Roberto Tischetti, 232223. And Detective Sergeant, your name for the record, please.
Sergeant Ken Grote.
All right, please raise your right hand. You solemnly swear from the testimony about to give this going to be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, thank you. And excuse me, you may proceed on the warrant.
October 10th, approximately 11:50 a.m., Officer Barwick arrived at the CVS located at 2025 Ford Avenue in the city of Wyandotte on an unrelated service call when he was approached by an unidentified female. The female stated there's a shirtless white male defendant, Mr. Tischetti, sitting in masturbating. Officer Barwick was directed to a beige-colored Chevy truck that was parked in the seat where he positioned his fully marked patrol car behind the truck. Officer Barwick noted that he observed the defendant was shirtless inside the truck, and as he approached to make contact, the defendant became startled and lifted the lower half of his body as if he was pulling up his pants. While speaking with the defendant, Officer Barwick confirmed the defendant's pants were halfway down and his bare buttocks was in the driver's seat and his genitals were covered up. Officer Barwick continued to ask the defendant why his clothes were off in such cold weather, 50 degrees that day, where the defendant became increasingly nervous. Officer Barwick and rolling up his window and stated he had to leave. Officer Barwick advised the defendant he was not free to leave, where the defendant disregarded all officers' commands and to stop, and the defendant fled the scene in his vehicle towards 4th Street. Officer Barwick activated his emergency lights and siren on his patrol car and pursued the defendant, who led officers on a slow vehicle pursuit through the residential area, disregarding officers' lights and siren. The defendant was observed himself while evading officers. The defendant was stopped and the vehicle was subsequently arrested and conveyed to the Wyandotte Police Station where he was booked and held. Officer Barwick noted that he was extracting the defendant from his vehicle. His arm was sweaty and covered in Vaseline. He also reported there was an empty jar of Vaseline recovered from the vehicle.
All right, thank you. Upon examination of complaining witness, I find the offenses charged were committed and there's probable cause to believe the defendant committed those offenses. Counsel, your appearance, please.
Yes, again, good morning, Your Honor. I'm Neil DeBlois, P36827 on behalf of the defendant.
Thank you. Sir, your name for the record, please.
Joe Tischetti.
All right. Joe, can you close that door back there, please? Thank you. And counsel, as to the arraignment.
Yes, regarding the arraignment, client would waive any further formal reading of the charges, stand mute.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. Schedule this matter for probable cause conference on October 19th at 9 a.m. And sir, you do have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Yes.
I can't hear you, sir. Sir, I need you to speak up, sir.
Can you repeat that, please?
You have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Yes.
All right. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir? I can't hear you.
Yes.
Okay.
I understand.
And
And counsel as to bond.
as the bond, Mr. Tischetti advised that he's been a 28-year resident on the home of Taylor, he's owned business for the last 30 years, indicated to me that he's never failed to appear for any scheduled court appearance. Indicated he has no pending matters. In case he will appear if released on bond, I'd ask the court to take those factors into consideration when setting a bond in this case.
All right, thank you. And Detective Sergeant as to bond.
Your Honor, it's like Mr. Tischetti has a problem with this. Since 1974 through 2007, he's been arrested and convicted 6 times of indecent exposure. He He's in a parking lot of a busy business in the daytime, and then he decides to flee in a vehicle. We think he's a danger to society. We're gonna ask for 10,000 cash.
Mr. Tashadi,
Yes,
you're self-employed,
yes.
and do you, participate in any, treatment, sir?
At this time, no.
Have you ever failed to appear in court for any reason, sir?
Haven't.
Are you on probation or parole anywhere?
No, I'm not.
Are you out on bond in any other jurisdiction?
No, ma'am. No, Your Honor.
All right, the court will note after review of the criminal history and taking into account the offense charged, and given the nature of the charges and the safety of the public, that is a huge concern for this court, given the defendant's criminal history. The court does find that the bond recommendation is appropriate. The court's going to indicate a $10,000 cash bond, no surety, no 10%. In the event you post bond, sir,
Pardon me?
in the event you post bond, you are to have a GPS tether, house arrest.
How would I go to work?
Sir, you'll have to communicate with the tether unit as to where the locations of any jobs are, but you're going to also have to submit proof of those jobs and that you're not just going to various locations without actually having any work to do.
Okay, how do I get that from like a customer?
Well, sir, if you're trying to prove that you're going to a customer's home and you're self-employed, one would presume that you would have a bid of some sort or some type of written contract that you can submit.
That's fine. I have that.
All right, and then we'll see you on October 19th. Thank you.
Thank you.
I have
The court will call the matter of the state of Michigan versus Appella Ward, case number 22 FB 1294. This is a PD case. I'm not, this would be Mr. Lebos.
No problem, Your Honor. I'm so sorry. Assistant Public Defender Jay Bellinger on behalf of Ms. Ward, who appears via Zoom. Ms. Ward, can you please state your name for the record?
Urquella Ward.
Thank you. Good morning, Ms. Ward.
Good morning.
Ms. Ward is here for a review today, and it is my understanding that she has not provided proof of her community service hours and is upset that the court is requiring that she do the community service in light of her having to take care of her mother.
Certainly, Your Honor. The notes that I have here are that she has not been able to do that due to her mother needing the 24-hour care. She's not been able to find any online options. She will obtain a doctor and submit to the court as soon as possible, is my understanding. I don't know if Ms. Ward has anything to add to that.
Anything from you, Ms. Ward?
I wasn't they didn't tell me that I had to, that I had an option for online. They stated that they were going to find me online, something online for volunteer work. I wasn't supposed to find it. And I'm not upset, Your Honor. It's just that I can't do it. I'm not upset at all.
Ms. Ward, you were convicted of a weapons offense in this particular case.
Correct.
And there are responsibilities that you have that you need to complete. If you don't complete them, then the option is to put you in custody.
Okay. Well, if I can't, Your Honor, what do you want me to do? I can't do it.
Ms. Ward.
If they give me option, if they can find something for me online, then I'll do
No
it.
one is
But
finding anything for you, Ms. Ward. You're confused about how this works. This is an
they
order.
stated to me
Ms.
that they
Ward,
were going to find it.
I'd recommend not talking back to the court.
Your Honor, I can't, if I could, I would do the time. The volunteer work or what is it? Cause I don't know.
Community service, and Your Honor.
Community service. I would do it, but I'm not able to do it right now. I'm not.
Your Honor,
I just can't.
Your Honor, I'm talking over Ms. Ward to encourage her to stop talking for her own sake. But I'll also refer to my notes from our last hearing, because I had brought up that I was actually the one that brought up the possibility of perhaps something existing online that she could do. My notes state that Your Honor told her she needs to talk to her attorney about those options. Mr. Lebo did say that he was going to reach out to her with to discuss that possibility. So if there has been a misunderstanding about what that private communication was supposed to be, to some extent, my notes are actually somewhat consistent with that. But I think it's also clear at this point that there needs to be some sort of initiative taken to at the least reach out to counsel. So I'm just, that's all for me.
Your Honor, I would be asking for a little more time on this, that we reset this review hearing to such time as we can speak with Ms. Ward about her options, be it online, in person, whatever she needs to do to come back into compliance so that she can be successful with this. I understand that she has hardships, but the court needs to take priority, and we need to just have a conversation about that.
Ms. Ward will be here on November 9th in person, 2023 at 10 o'clock a.m. Ma'am, you need to work on that community service as you were ordered to do. And if you don't, then at that time you'll be taken into custody. And if you don't show, I'm going to issue a bench warrant for your arrest.
All right. Thank you.
You're welcome.
Thank you, Your Honor.
We'll call the case of the State of Michigan versus Jane Pitts McGowie, case number 23 FB 1310.
Assistant Public Defender Dr. Lee on behalf of Ms. Pitts McGoy.
Good morning, Your Honor. Jane Pitts McGoy.
Good morning, Ms. Pitts McGoy. Could you please show your screen for me?
Can you see me now?
I can. Thank you so very much.
No problem.
All right, we're here for sentencing today.
Yes, Your Honor, I have reviewed the report and recommendation with Ms. Pitts McGoy. So the only modification we would make is that I'd like the court to note that Ms. Pitts McGoy has indicated to me that she does take responsibility for taking some of the items identified in the police report, or with her statement to the probation department. She apparently was indicating that there were certain other items that she did not take responsibility for. That said, she certainly regrets her actions and asks the court to accept the recommendation.
All right, Ms. McDuffie.
Your Honor, not too much I agree with the recommendation. I'm just scanning this quickly to try to get a handle on what the exact amount is going to be. Obviously, we need to pursue that further and get verification for that fair amount that was agreed to in the plea agreement for restitution. But other than that, I agree with the recommendation.
Well, excuse me, it never was no amount agreed to in the recommendation. That was something that...
Ms. McGoy, you're going to be given an opportunity to talk, but this is not yet that time.
And just to be clear, Your Honor, the plea form states that a fair amount is to be paid. So I was referring to those words, no specific number, but that number had to be determined.
I was only speaking because he was not my attorney, so he's not familiar with my case. I'm familiar, so I don't want nothing to be placed on the record that's not true. And he's talking, and he has not even been my attorney this whole time. So I will correct you if you're wrong about something, because I don't want something to be on the record that's not true, and then it be something different. That's all I was doing. So my apologies, Your Honor.
So the plea form says, which is the plea form that your attorney at the time signed, says that you must pay reasonable restitution. Ms. Pitts McGoy, is there something you would like to say prior to sentencing, ma'am?
No, ma'am.
So, Mr. Lebo, are you requesting a restitution hearing at this time?
Your Honor, my understanding is that would depend on exactly what the amount of restitution being requested is, and we do not have that number at this time.
And how do you plan on coming up with that number, Ms. McDuffie?
Your Honor, I'm scanning this report. Obviously, this is something that was remanded, so I wasn't involved in the case when it was pending in the PCC stage. So I'm trying to get some clarity, and I don't have the ability to do that right now with respect to any items that might have been recovered, returned. I just don't know that at this point. Most of this is apparently cash and lottery tickets. So I'm assuming that the cash is not something that was recovered because it wasn't something that was caught at the, at the time, and prevented from leaving the establishment. But I just wanted to follow up with some of the other folks that handled this case previously to get any more details that might be there I'm not aware of. So we can set it for a hearing because one way or the other, we need to come up with a number. So I don't, it may be that we need one regardless.
Well, I'm gonna loop and Speedway submit whatever documentation that they believe they have. I don't know how they can determine this.
When it comes to the lottery tickets, I know I've prosecuted some other cases before, in another court where we were able to actually track the specific ones that were missing, reported missing, because there's very strict accounting that goes between that and the state office. So that could take me a bit of work to follow up on, but I may be able to get that information too.
Okay. And then they're claiming $1,200 in general merchandise and then another $210 in Newports. And is there a way that there was a video? Correct?
It looks like there is at least some surveillance screenshots from video, and I can't make it out because it's a little bit tiny on my screen, but it looks like there are some ledgers or some other accounting of some sort of items from this case. I just can't clearly see it. It's rotated and very small on my screen, but it looks like there's a balance sheet in the police report that is apparently supposed to document what was taken here some kind of way.
Excuse me, Your Honor. So I'm at the point to where now I really want to reject my plea because that's not true. It never was no cash took. It never was no cash taken. And if they got video, that video gonna show that. There never was no cash taken out of the drawers at all at Speedway, not one time. And it definitely wasn't no $2,000 worth of lottery ticket. And if they got video like they say, then that should be that I really prefer for my lawyer to request that. So when we do go through this restitution process, I'm not being overcharged for something I know I did not take.
All right. Anything else you want to say today, ma'am?
Me?
Yes.
Oh, I'm sorry. No, I just want to clear that up because I don't want to be, that's why I pleaded no contest, because I don't want to be held accountable for something I did not do completely. I'm not, and I don't feel like I don't feel like I should have to pay for something I didn't do. I never took cash from them people. I never took $2,000 worth of lottery tickets. None of that stuff that they accused me of is true. And if this prosecutor got cameras, then when it's time for this registration court hearing, she needs to produce the correct evidence that they're trying to say, because then it's going to show that it's a bunch of lies. What they said, they're not once they're going to see me taking no cash, no $2,000 worth of lottery tickets, nor no cash from Speedway, period, point blank, or no $1,200 in merchandise. That's a lie too. So I prefer for them to get that video on footage. I know they got 60 days. It shouldn't take that long. It shouldn't take 60 days to get it. So I can hurry up and pay what I do and what I am responsible for and just put this behind me and work on me. But I can't just be like, oh, I'm about to pay this to please the next person I know I didn't take what they accusing me of.
So if I could just inquire of the court, I'm not sure if we are proceeding with sentencing or if there's going to be an attempt to withdraw the plea in this matter. Where are we with this, please?
My last discussion with Ms. Fitzmagoy, which was yesterday, she did not indicate to me that she was wanting to withdraw the plea.
Yeah, that's true too, because also when I talked to you, I didn't hear that no prosecutor sitting there accusing me of a certain amount. That's not true. I also didn't hear that neither when I talked to you yesterday. You never once mentioned to me, oh, they saying you stole $1,200 in merchandise. They saying you stole this amount of cash. Never was no cash took. So it is confusing when all the conversations are not in the same circle. You got one conversation this way, one conversation this way, one conversation this way. That is very much confusing. And I'm not going to plead to something that I did not do. That's what I'm just not going to do. I'm not going to pay for something that I did not do. That's not what I'm going to do.
Anything else today, ma'am?
No, ma'am.
All right, ma'am. You're here on sentencing. and you've spoken and I've allowed you to do so. Please don't interrupt me, okay? Just so you're clear. You're here for an embezzlement charge. You did plead guilty or no contest, as you say, which does not in any way, shape, or form mean that you are disputing what is being alleged. When you plead no contest, in reality, what happens is no contest means that you accept the allegations as they're made in the report. That is what no contest means. The court gets to review the allegations in the report and accept them as true. That's what a no contest plea is. Means you're not going to say you did it. You're not going to say you didn't do it, but the court is going to treat you as if you're guilty of what's in that report. That's what no contest means. Having said that, you're here for sentencing on this today. The court is going to sentence you as follows: 365 days in the Washtenaw County Jail, credit for 1 day served, 364 days are suspended. You are on probation for 12 months. You have fines and court costs in this particular case for a total of $425. Restitution is to be determined within 60 days. You're to complete the Crossroads shoplifting program. Do not go to Speedway store in Ypsilanti. Meet with probation when and where directed, including any and all home visits. Make earnest efforts to maintain legitimate employment. No assaultive or threatening behavior towards anyone. You submit to, pay, and be responsible for random drug and alcohol tests as requested by the court, probation, or probation officer. In fact, you are to report within 24 hours to be tested for ETG as well as substances. If you have a negative, then there will be no further testing. No use or possession of alcohol, marijuana, either medical or recreational, and no drug paraphernalia, no being in the presence of anyone using that. Same is true for firearm components, ammunition, or other dangerous weapons, and no being in the presence of anyone carrying or using them. We'll do a review in 60 days. That's going to be on December 14th, 2023 at 10 o'clock a.m. At that point in time, I expect that any restitution that is being requested in this case will have been provided to this court in that request, and we'll schedule the restitution hearing after that time. If it comes in before then, that would be beneficial, and we can have the restitution hearing on that date. Any questions, ma'am?
Yes, I have a question. So, I don't currently stay in Washtenaw County. So, and then I have another case that I'm dealing with where I'm not even supposed to be driving. So I'm trying to figure out, like, I don't have no problem drug testing, but I'm trying to figure out where would I go to drug test at, because I can't get to Washtenaw County. I got 2 kids and I just started a job today. So I don't know if we can work out something with me doing something in Detroit, and I can try to find a ride, but I don't have no ride to get out there.
Yeah,
and I'm also not trying to violate and be taken from my kids.
You can test in Detroit, ma'am. I don't have a problem with that. So you can talk to the probation department when you call them. Actually, I'm going to give you I'm going to give you 48 hours to test if you need a place in Detroit to test. Okay.
And I was never, and then another thing, my last lawyer didn't explain to me what the no contest was. He didn't say that y'all was gonna go based upon any allegations. He said that I was technically not admitting or declining, but he was running back and forth in the courtroom that day. So he never really broke down what the no contest was, or I wouldn't have played no contest. I would have just took it to trial.
Well, I think you have to talk to your attorney about that now. Okay?
Okay.
Will you hand me my screen box?
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.